Hi there, I'm James Zappachi, and this is Coffee and a Case Note. So what happens if you come to court, you've asked for the court to give you a certain type of relief, you get it, but not for the reasons you thought. Today we're dealing with a fact pattern that might sound a little bit like a family provision claim for anyone with experience in that area, but it's sort of a little bit of a 45-degree twist on those sorts of facts. So what are we talking about? We're talking about a dry cleaning company that in 2003 sort of stopped its real dry cleaning affairs and then essentially became a property holding company. And the two shareholders in the company were Mum and Dad, 50-50 shareholders. Now in about 2004, Mum passes away. Mum and Dad have 3 daughters. And Mum leaves her shares equally to each of her and Dad's 3 daughters. Easy, so far. And it stays easy. It'll be fun. There is a strange administrative blip in about 2004 where each of the 3 daughters appear to be appointed and then removed as directors, and the affairs of this company are quite informal. So I just want to plant in your head that there's a funny administrative moment about a directorial appointment in about 2004. But anyway, the company chugs along, and 2 of our 3 daughters are the recipients, or entities related to them are the recipients of loans made from the company on terms that are not really strictly commercial, and the loans are unsecured. In any case, Dad remains the director of the company, and the company marches on doing its property holding thing. In about 2012 or so, Dad appoints our 2 other daughters, and you'll see why I call them that as we progress with the facts, as his attorneys, and our 3rd daughter commences proceedings in what was once called the Guardianship Tribunal here in New South Wales, now known as the NCAT, in respect of these attorneys, essentially challenging them. Now, as part of that challenge to the attorneys, there's a mediation. As part of that mediation, a memorandum of understanding is signed between our solo daughter, our duo daughters, and Dad's solicitor, who signs the memorandum of understanding. And essentially the nature of that memorandum of understanding is that Dad, or perhaps these 2 daughters, will buy our 3rd daughter's shares from her for an amount to be figured out once we've got some valuations. The reason we needed to agree on this is that a couple of years beforehand, Dad had made what might be thought of as a bit of a derisory offer to buy our 3rd daughter's shares. What had also happened is that the accountant, had circulated an email with a valuation of our 3rd daughter's shares that she had immediately said, right, I'll sell them to these 2 and Dad for that amount, and these 2 and Dad did not end up accepting that offer. So there's a bit of a background of our daughter here trying to sell her shares and get out. Right. So let me take you back to this mediation of the Guardianship Tribunal, to the Memorandum of Understanding. There is a Memorandum of Understanding. The suggestion is, we will get some valuations and we will try to agree and we will then execute the sale of shares from 3rd daughter to the other parties based on this mechanism. Doesn't happen. Dad dies in about 2015. And what our daughter here tries to do, well, what she in fact does, is she commences proceedings seeking specific performance of the Memorandum of Understanding. So she's suing to say, do what you agreed to do. Essentially, she's suing to say, let's get the valuations and have my shares sold in accordance with them, in accordance with this memorandum. What she also does is seek to have the company wound up on the grounds of corporate oppression. Now, let's take the specific performance point first. In short, the court found that there was no intention that that memorandum would lead to binding legal relationships. It was sort of expression of an agreement to agree, as some lawyers might put it. It was an expression of a mechanism that might one day lead to an agreement, but it was not an agreement in itself that could be the subject of specific performance relief. So we then turn to oppression. Our disappointed daughter said this weird administrative blip in 2003, 2004, that was oppressive. Court didn't agree with that. The daughter said, Dad offering me a derisory offer of 660 grand for my shares was oppressive. Court didn't agree with that. The daughter said, the failure of my sisters and my dad to accept my offer in accordance with the accountant's valuation was oppressive. Court didn't agree with that. So we have our third daughter going down on specific performance, going down on oppression. But, and if I can just remind you that the relief our daughter was seeking in the oppression point was for winding up the company. It wasn't for what often happens in oppression proceedings, which is seeking a share sale. So what some of you might have assumed, and what I assumed when I first went through the fact is, oh, she's going to seek an order, that there be some valuation mechanism, and the other shareholders have to buy out her shares. No, what she was seeking was a winding up. And what actually happened was that the court ordered that the company was to be wound up, but that was because since Dad's death there had been no director of the company, and one of our baddie daughters, and I use that very loosely without judgment on the parties of course, had been appointed as attorney for the company and had been running the company as its attorney, but the company had been without a director. And in short, that was a basis for winding up the company, which is what happened. So can I take you back to our question at the start? What happens if you get the relief you want, but not for the reasons you were contemplating? Well, that's exactly what happened. That's exactly what happened here, where our daughter tried to get this winding up relief on the oppression basis, failed on the oppression basis, but the court made the winding up relief. So what happens if that happens? There are costs implications, and the parties spoke about it at length, and the court thought carefully and deliberated in a really useful way, if you're inclined to read the judgment, on costs. And what was eventually found was that our defendants, Dad's estate, our two sisters here, were obliged to pay 25% of the legal costs of our disappointed daughter on the basis of her having success in getting the relief she was after, even though there was incurring of the cost for a failed oppression suit and a failed specific performance claim arising from that memorandum of understanding. Now, hope that helped. And the way I hope it helped was to give you a bit of a window into how claims can be framed and how relief can be sought. And what I also hope is that sometime soon you will be in a position to join me, and I will be in a position to join you for another coffee and another case note. Thanks so much for joining me for this one. Cheers.